the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power, and excluded the existence of arbitrariness of prerogative or even a wide discretionary authority on the part of the government. The doctrine of public interest immunity has been an ongoing, growing and developing concern to every court of law. Therefore, it is pivotal to trace back to the early days to encourage an in-depth understanding of the evolution of the public interest immunity. By acknowledging its historical background, one gets to grasp the definition of public interest immunity as well as the idea of the transformation of Crown privilege to public interest immunity. Moving on to the evolutionary process, this presentation will shed light on issues of the public interest immunity, namely the balance between public interest, the distinction of class-based and content-based claim, the obligation to claim for public interest immunity certificates, the variation in civil and criminal contexts, the protection of the informants, and the right to silence with regards to the principle of public interest immunity, not forgetting the application of Attorney General's guidelines. Lastly, this discussion will end with a complementary evaluation of certain concerns identified throughout the evolutionary path.
Public interest immunity is the doctrine of English common law that can be applied by the English courts to grant a court order allowing one party to refrain from evidence disclosure to the opposing party due to the fact that the disclosure will possibly damage public interest. But what is public interest anyway? The one simple definition according to the Black's Law Dictionary is that public interest is the comparison between the welfare of public individual or company and the welfare of the general public. This is where the society has a stake in that interest, and it is for the best interest of the general public for the state to not release or disclose the information, or else such information could potentially spark riots and disturbance within the realm. This doctrine of public interest immunity is an exception to the usual rule that claimants and defendants of a case are obliged to disclose any relevant evidence. By applying a public interest immunity order, the court is in a position to make balance the interests of the public in the administration of justice and the means of maintaining the confidentiality of the documents which the disclosure of them will bring harm to the society. Before the public interest immunity came to effect in the courts of England, it was Crown privilege that was ordered in courts until the late 1940s, when the Crown privilege was abolished under Section 38 of the Crown Proceedings Act 1947. This explains why the Crown is obliged to disclose documents when ordered by the courts, unlike before. But if we look back to a case in 1942, the case of Duncan and Camille Lyons and Co., the House of Lords held that no matter if the Crown was a party to a proceeding, documents which potentially endanger the peace of the kingdom should not be produced due to public interest. This rule was later put in by the courts, where under Section 28 sub 2 of the 1947 Act, they should not disclose the relevant documents if, in the opinion of the courts or the Crown, that the disclosure would be injurious to the public interest. Hence, this marked where the doctrine of public interest immunity came to light. The historical context for the issuing of public interest immunity certificate, the Arms Lawyer case came particularly intriguing for this subject. Because of this case, the doctrine has always been under the spotlight of political and constitutional controversy. The Arms Lawyer case was about the sales of arms by UK companies, especially the company Maastricht Churchill, to Iraq during the war between Iraq and Iran. Public interest immunity certificates, which was usually not deployed so extensively, was used deceitfully by the government to prevent the defendants, which is the parties of Maastricht Churchill, from accessing documents and information which later proved their innocence. As it turned out, the evidence were not really important as of the level of national security. The certificates were used by the ministers involved in the scandal with the attempt to prevent the publication of alleged embarrassing information of the government. The topic of public interest immunity was very much discussed in the report, namely the Scott Report, which was a judicial inquiry commissioned after the scandals of Iraq arms to Iraq. The report discussed public interest immunity extensively, giving numbers of ideas for reform and the details of how public interest immunity certificates were issued by the government in court cases. Ever since, reforms on this doctrine has been made, and most importantly, abusive use of the doctrine and certification are less likely to occur in present days.
In the 20th century, public interest immunity has been applied in a wide array of civil cases. The landmark case regarding the application of public interest immunity in civil proceedings is the case of Duncan and Campbell Line and Company Ltd, where an action was brought for the loss of life of the victims when the submarine sank during trials. Disclosure of document in relation to the contract between the Admiralty and the submarine contractors, as well as the service report on the submarine, was sought. However, the defendants were instructed by the Ministry of Defense not to disclose any content of the information on the ground of national security, and the minister certified that the disclosure was against public interest. In this case, the House of Lords held that the certificate of the minister was conclusive and could not be questioned. Where the Crown claimed on the basis of Crown privilege or public interest immunity, the courts were prevented from further investigation and the particular information will not be disclosed. Over the years, public interest immunity has constantly evolved, and this can be seen in several aspects. In the wake of the case Duncan and Camel Line Company, the Crown was the only authority who determines whether Crown privilege would be claimed. As stated by Sir William Wade, the Crown was given the legal power to override the rights of litigants not only in cases of genuine necessity but also in any cases where the government thought fit. However, as times go by, following the recent case of Conway and Rimmer, it was the court, not the Crown, who had the rights to decide whether a claim of public interest immunity would be allowed now. The courts were entitled to maintain a balance between public interest to prevent the disclosure of particular documents and the public interest to ensure proper judicial administration. On the other hand, previously, in content claims, it was argued that the public interest would be damaged through the disclosure of the content of certain documents, while in class claim, nothing in the document would lead to the damage of public interest even if they were disclosed. Evolving through the years, it was also justified that class claims with regards to central government documents would lead to public or political criticism due to the disclosure of documents about the construction of government policy. However, these class claims were then criticized in the Scott reports, as this inner working of government class was wide, and thereby many ordinary documents produced within the civil service were included. As a result, the government introduced a brand new approach to the public interest immunity, and the essence of this new approach is the abolishment of the long-term distinction between class and content claims to public interest immunity. The class claim will no longer be adopted. This can be seen in the case of Art and Chef Constables of West England and Police ex parte Willie, where the House of Lords overruled the decision of the Court of Appeal in Nelson and Lahore and held that a class claim did not apply to the documents with regard to witness statements and the like, since complainants would not necessarily be frank in making statements to the investigating officer. Instead, as suggested by Lord Templeman, public interest immunity should be assessed in the aspect of whether disclosure of the document would substantially damage the public interest. Furthermore, the issue of duty of claim of public interest immunity had always been subjected to argument and had been involved throughout the years. Following the Scott report, the dictum of Lord Birmingham in the case of Makanjuala and Commissioner of Metropolitan Police was taken into account. It was contended that where a litigant affirmed that a document was immune from the disclosure on the ground of public interest, he was observing a duty. Brigham suggested that a litigant who holds the document in the class prima facie immune was under an obligation to affirm that the particular documents were subjected to immunity and refused to disclose them. It was the court, not him, to judge where the balance of public interest lies. In this case, the relevant minister was under a duty to claim public interest immunity, and the Attorney General has the right to advise the minister. Similarly, in the case of Burma High Company and Government and the Company of the Bank of England, it was the minister who issued public interest immunity and declined the disclosure of the meeting minutes between the government and the Chancellor. At this current state, the government announced that the standpoint where the minister was under a legal duty to claim public interest immunity has been abolished. Instead, the balance of public interest has to be weighted, and a ministerial certificate which sets out clear details of the real damage or harm to the public interest is needed for a duty to claim public interest immunity to arise, avoiding the disclosure of that particular document.
Looking at principle of public interest immunity, leaning towards criminal matters, the first attention had to be drawn to the landmark case of Ex parte Willie. Lord Templeman stated that the disclosure of information which is pertinent to the case can be denied. Release of material that might be average, lost or difficult to get hold of can be refused. But if the public interest demands, it can be deviated too. Therefore, equality of arms must present in PII. One of the legal implications of this case is the question of the authority by which PII may be claimed in criminal proceedings. This is an issue which Judge Smedley considered in his ruling. He claimed that Conway and Rimmer, Burma Oil and Bank of England, and Air Canada and Secretary of State for Trade were cases arising out of civil proceedings and didn't have any great assistance. Hence, the court had decided that where the prosecution in a criminal cases conflicts that PII legitimized non-disclosure, a three-pronged approach must be embraced. First, the prosecution must notice the defendant that they are applying for ruling. Secondly, they should demonstrate in any event the classification of the material they hold. And thirdly, the defendant must have chance to present in the court. Evolving, public interest had also protected the informants who provide important information to the police. Case law had restricted relevant materials which could lead to the exposure of the identity of Section 21 of the Criminal Procedure and Investigation Act 1996 and amended by the Criminal Justice Act 2003 applied. Besides, an overlap between the principle of the common law of open justice, which requires maximum disclosure, present was proved in R against Davis, Johnson and Roe, as well as in Article 6 of European Convention of Human Rights. Mentioned by R against Hatch in 2003, the House of Lords ruled that trial judge should consider all the data that are accessible according to the nature of the PII, sought to ensure that the complete disclosure process does not uncover more than required even by the context of the case. In Marks and Beavers, Lord Asher precisely recognized that witnesses should not be asked about the identity of the informants, and it can protect the public interest and motivate individuals to provide information to the law and enforcement agencies. Nevertheless, there are exceptions if the context of the case is such that refraining from disclosing the identity of the informants may jeopardize the integrity of the trial by impacting on the correctness of adjudication in the case and leading to the innocent being convicted and imprisoned. These type of cases are usually quite rare, and this ratio was given by the House of Lords in the case of Ex parte Bennett. It was also held that if the disclosure of informants can be used to establish a defendant's innocence, the court will exercise its discretion and allow the disclosure of the informant's identity. This case reiterated the principles established in Makanjola and Commissioner of Police for the Metropolis, that it is an exclusionary rule imposed on parties in certain circumstances, even where it is to their disadvantages in litigation. In addition, notwithstanding the stringent punishment for terrorist offences, significant laws to prosecute terrorism are probably turning out to be increasingly pro-prosecution. Under new anti-association law in Queensland, stricter terms of detainment in the range of 15 and 25 years for anybody discovered blameworthy of group-related violation are established. The material, likewise, is generally sensitive for equity to be done in PII claims. In Sankey and Whitlam, Mason J. declared that the sensitive nature of terrorism must be carefully balanced against its potential to exculpate and accuse of wrongdoing. Another difficulty accompanying the use of PII in criminal proceedings is the status of Attorney General's guideline to prosecutors concerning the release of information to the defense in serious crime. In R against Crown Prosecution Service ex parte Ruby, the Divisional Court held that the choice of the CPS Crown Prosecution Service, taken under the Attorney General rules not to reveal, was not defenseless to challenge by method for judicial review, but solely in the Crown Court, a decision to claim PII, be that as it may, probably would fall inside the extent of legal audit, and in this way, this issue focuses to encourage disjointedness among PII and the Attorney General's guidelines. Geoffrey Robertson asserted in Matrix Churchill that the utilization of PII certificates in criminal procedures was an encroachment of the defendant's right to silence. Thus, the defense team has to disclose the outline of their case and the grounds for judges whereupon the defense will be arguing right to silence. As identified in Regina against Director of Serious Fraud Office, ex parte Smith, right to silence was not in fact one right but was rather a chain of immunities. It is a general immunity owned by every individual from being forced to answer under the threat to be punished and from being compelled to say anything which may be incriminating. It is also an immunity enjoyed by individuals suspected of criminal responsibility who is being interviewed by the police officer from being pressured to answer any query, by those on trial from being pushed to give evidence, as well as those who have been charged with criminal offense from having issued materials to the act confronted by the police. Lastly, at least in certain situations, this general immunity is shared by those on trial from having an unfavorable comment made on any failure either to reply to an inquiry before the trial or to provide evidence at the trial. Silence.
It is vivid that the major shift in the government approach to the claim for public interest immunity was prompted by the fact that drawing a line of distinction between the class of the document and its contents have become both unhelpful and obscure. Accordingly, the minister today need not apply the former division into class and content claim, but will focus on the damage which disclosure would cause to public interest. This approach can be regarded as a huge leap forward as it ensures that the public interest immunity certificate issued by the minister will set out in a greater detail than before by assessing what the material in question is and what the danger its disclosure will cause. It is also apparent that the government has recognized the need to ensure that ministers have adequate time in which to assess public interest immunity claims and undeniably recognized that ministers had a duty to claim public interest immunity for documents which might damage the public interest save in the most exceptional circumstances. It's fair to say that the tone of the government report suggests that they are willing to be less indulgent towards the government when it comes to public interest immunity claims. There are also intermediate stages of partial disclosure available under the new approach coupled with reduction, whereby a certificate that a document will be disclosed with a sensitive part blacked out have become standard practice since the ex parte Villa decision. Furthermore, other forms of partial disclosure such as summaries of documents may also be approved by the courts which was unheard of during the era when blanket immunity was accorded to the executive. However, on the other hand, the substantial harm to public interest test may be an indirect attempt to impose a higher hurdle than what was proposed and envisaged by the government due to the ambiguity of the said test as in the context of national interest, even a minuscule unquantifiable damages to national interest can be interpreted as substantial damage. This approach is also said to be deeply flawed as it still goes again to preserve the freedom of the minister to make class claim to public interest immunity in both civil and criminal cases. This is because although the government have moved away from the traditional labor class claim, but this is not guaranteed that ministers themselves would not apply class reasoning. For instance, the minister can be motivated to argue that the substantial damage to public interest may be caused by the disclosure of the document not due to its contents but due to its class belong to, thus blatantly subjecting this test to abuse. Another unfortunate problem where would be the refusal of the government to accept that one far-reaching test of substantial harm to public interest cannot be used simultaneously in both civil and criminal realm. This test particularly not suited for matter pertaining to criminal litigation, as under criminal law it is a paramount need to avoid miscarriage of justice. Hence, it would be no longer be logical to describe this approach as a balancing act under criminal law, as the court would not truly be concerned about the balancing the competing interests but preoccupied with the preventing of miscarriage of justice. It is also unfortunate that the government concedes with the opinion of Lord Scott when they also strongly believe that legislative intervention is not required in this area of law. This has led to inconsistent decisions in the case of Taylor and Anderton, where the court went on to uphold a class claim to public interest immunity for a report by an officer investigating a complaint against the police. Yet another distinctive flaw of this new approach is the fact that it is limited in scope, as it is only applies to public interest immunity certificate issued by the central government and not local authority, police and police department. Until and unless there is legislative intervention, these bodies are free to apply their own criteria as seen in Taylor and Anderton.
With all the concerns pointed out, the public interest immunity must be borne in mind alongside with Article 6 of the European Convention of Human Rights, which outlines the individual's right to a fair trial. With an appropriate procedure, the operation of public interest immunity is not necessarily a breach of the fundamental human rights, and thus the third postulate of Dicey's rule of law can be upheld by the court of law. Every citizen's right is protected by the English common law, and the judicial independence will play a crucial role to ensure a fair and just administration of justice, as the judge's tenure is secured by the Act of Settlement 1700. Another main concept of constitutionalism, the separation of power, will then also come into the picture, as the judiciary is entitled to have check and balances on the executive by way of judicial review. In conclusion, the public interest immunity have evolved in a seemly and decent direction, which the extent to which governments may be required to disclose information to a court of law has increased, and the discretion has been shifted to the court's hand. Although certain concerns still prevail in today's world, a government should accept that in a healthy democratic society, it is inappropriate to take public interest immunity for granted in order to seek to behold their modus operandi. Without judging the rightfulness of claiming a public interest immunity, there should always be an inclination in favor of an open government.